Hello, my name is Ryan Dillon. I am a criminal defense attorney in Franklin, Indiana. I also have an active civil practice as well as do quite a bit of work defending indigent defendants before the courts in Johnson and Morgan counties. Uh, the purpose of this discussion is to advise the public about some of the changes that occurred last year in the criminal code reform. There were a lot of changes that went on. This discussion is focusing primarily on the penalty changes that occurred. So there are two categories here, offenses that were committed before July 1, 2014 and offenses committed after. Um, Anything committed before July 1 is still going to be operating under the old code. Uh, you should consult with a lawyer to make sure you understand which of the two you are needing to worry about. But anything committed after July 1 will be charged under the new code. Only the felony penalties have changed. So Class D felonies, or what used to be a Class D felony, carried 6 months to 3 years with an advisory sentence of a year and a half. Now we have level 6 felonies. Similar sentences. It's actually slightly less on the advisory sentence. C felonies used to be 2 to 8 years with an advisory of 4. Now we have level 5s. Class B felonies, which used to be 6 to 20 years with an advisory of 10, have been split into level 4 felonies with 2 years to 12 years and level 3 felonies with 3 years to 16 years. And then the most egregious of offenses, Class A felonies, have also been split into level 2 and level 1 felonies. What else you need to know about the penalty provisions? The legislature significantly changed the credit time statutes. Misdemeanors and level 6 felonies will continue to get what is now known as Class A credit, which is day-for-day credit. So for every day that you would serve in jail or on home detention after sentencing or work release, you would be entitled to 1 day of credit for that as well. Anything level 5 and higher is a sentence in which you serve 3/4 of the time. There were also several changes to the Department of Correction credits. All drug offenses are now suspendable. Courts are not exactly adopting that as of yet. That is one of the primary reasons for the criminal code reform, was the fact that the prisons were being overfilled with drug offenders instead of people who really needed long-term incarceration. But as of now, the mechanisms are just now being put in place to deal with drug offenders in county community transition programs. And where inmates are serving sentences is also changing. Any level 6 felony is generally going to be served at a county jail as opposed to being taken to the Department of Corrections, unless it is a probation violation. And even then, unless the sentence is in excess of 2 years, generally those inmates are staying in the county jail. Hope this has been helpful. If you have questions or want to discuss your criminal case, give us a call, 317-738-2525. Our address is there on the screen. You can also check us out at www.dillonlegalgroup.com.